Welcome to Dignified Family Transitions with Lilie the Lawyer.
Welcome to Dignified Family Transitions with Lilie the Lawyer. Lilie McRoberts is a Minnesota family law attorney and mediator who helps individuals and families navigate divorce and custody matters with a focus on problem solving, not conflict, and practical, respectful solutions. I'm Shameika Rhymes, and today we're talking about what happens in a Minnesota divorce when you and your spouse already agree on most things. Welcome back, Lilie.
Hi, I'm so happy to be back. Thank you so much for having me.
If two people going through a divorce feel like they agree on most things, what does the process actually look like from there?
So you've come to a decision, and you came to the decision together. So the very first step is the hardest part. When you are in agreement, the first thing that you're going to do is, or if you are agreeing on most things, the first thing that you really should do is either, if you want to hire an attorney, go ahead and reach out to an attorney. If you decide that you want to at least get it through the initial stages, to take a crack at it yourself, then go to minnesotacourts.gov and go to the Minnesota self-help page, navigate to divorce, and go ahead and find if you have children, do dissolution with children, joint petition. If you don't have children, then do the no children. That is going to give you an instruction sheet of everything that you need to know in order to file a divorce, and it actually has the divorce paperwork. So that's going to tell you all the information that the judge is going to need in order to file the paperwork in the first section. The second section is going to be, how do you want to divide your assets? And if you have children, who gets custody, what custody is, and what the parenting time looks like. And you're going to need to go through and figure out and be sure that you're in agreement on absolutely everything by answering those questions together. Now, if you come to a question, you're like, oh, I hadn't thought of that. Because the thing is you're not going to think of everything. Mm-hmm. That's why you're going to do this paperwork. And you're like, I don't know exactly what we want to do there. Maybe we should talk to an attorney. Maybe we should each talk to our own attorneys. Or maybe we should schedule a mediation session. And the nice thing about scheduling a mediation session, if you don't know how to address that particular issue, is if you're at odds with each other, you really should each talk to your own attorneys. But if you just don't know how you want to resolve that, you can go to a third-party mediator, and they can help you through that particular discussion. And then they can help you come to a resolution on that potentially. And then you would do a mediated settlement agreement if you wanted to do it that route. So if you go through the entire joint petition and you agree on absolutely everything, finish the paperwork, get it filed. You might each want to talk to your own attorney to just review the paperwork. Mm-hmm. Or if you had the attorney with you the whole time, then you wouldn't need to worry about that. But then you probably wouldn't be watching this podcast anyway.
Good point.
But if you are in agreement on everything, then you would just file the paperwork. And then sometimes the court can accept that paperwork without having a hearing. Otherwise, the court would have a hearing just to make findings of fact on the record, and then the judge would sign off on that, and then you would be divorced. But so that's if you agree on all things. But if you agree on most things, what you would do is you would go through and you would identify the issues that you don't agree on. And then, like I said, either you get an attorney or you go to mediation. So let's just say that you go to mediation, or the attorneys take you to mediation. So let's just say that you go to mediation and you have a list of like 3 items that you still don't know exactly what you want to do. Then ideally in mediation, you figure out exactly what position each person's coming from and the reasons why they want what they want. And then ideally they communicate that to the other party, and the other party is like, I don't really care about, but I care about this thing. And then the other person's like, well, I don't really care about that thing. Or let's find common ground. And then most of those cases, then after that mediation, you'll leave with a mediated settlement agreement. And if you have attorneys, they'll file the paperwork for you. Otherwise, you can get the paperwork online and file it. And then again, you'd file what would be a stipulation at that point rather than a joint petition. The court gets it, reviews it, and then you may or may not have to have a hearing. And then if you have a hearing, then the judge signs off on it. Now, let's say you don't come to an agreement after mediation. It's unlikely if you were in agreement on most things, but then let's say you just can't agree on those few things, then every once in a rare while you would go to trial because you just can't decide this one thing. But then the trial would be very limited. It would still be the judge telling you what the judge's decision is, but it would just be only on that one issue. Everything else would have been decided by mutual agreement. And even then, that's something to be proud of because you have that buy-in and you had that control over 98% of the issues that, a lot of people, don't necessarily have that control over when they go to trial. But you could have a trial on just the one or two issues, and it would be a lot more cost effective than going to trial on everything. So
where do you see that couples tend to realize they don't actually agree as much as they thought?
Sometimes people don't realize that dividing assets is quite as difficult as it really is. A lot of times I hear people come to me and they're like, well, I just want what I have that's in my name, and I just want this person to have what's in their name going into it. But then when they learn about what their rights are in Minnesota with respect to personal property and all property, when they learn that in Minnesota, marital property is everything that they have is marital property from the time that they were married until basically the valuation date, which is like the first hearing in a family law case, they find out that they're entitled to, and rightly so, half of the marital estate, an equitable division of the marital property. When people find out what their rights are, that can sometimes sort of derail an agreement, but it's really, really important that they go through that step, because looking back, if let's say a partner finds out like they just wanted to have what they brought to the marriage, but let's say that they were home raising kids, and the other person was the breadwinner, but they kept everything separate, So then the one person was living, with not an income, and the other person had an income, and then they want to get divorced. It wouldn't be an equitable division if that one person only had access to what they brought into the marriage by their own earnings because they were raising the children, right? So Minnesota really thinks of marital property as you're one person, and you may have two incomes, you may have one income, but you're building an estate together, and Minnesota presumes that each person is equally contributing to that estate. And so I think the biggest issue that people have is they have in their minds, they don't understand that they're entitled to half of an equitable division of the property. And then they maybe are getting pressured, maybe not, or maybe they just really are feeling guilty about getting the divorce. And so the more that you can kind of remove those sorts of emotions, feel them, process them, but don't let them be part of the decision making, the more equitably you'll be able to get through the divorce onto the other side. And even if the negotiations temporarily break down once people realize what their rights are, and worse yet, you feel like you have an agreement, but then you have to tell a person, well, I didn't know that when I made that agreement with you. The courts are going to want to equitably divide the property. Mm-hmm. So it's far better to go deal with that temporary conflict so that on the other side of the divorce, you can both feel like you had your rights upheld, than to go through and and sign off on the paperwork and then have the resentment in the future, especially if you have kids. So yeah, I do see it breaking down when people do learn what their rights are, which is why it's so important to talk to an attorney when you go through this, because the paperwork doesn't tell you that. Or at least make sure that you take some time to understand what marital property is and isn't by looking at the definitions. But regardless, it's usually better if those negotiations break down, because that means that there's a piece of information that you didn't have before. I would say that's where I see the negotiations break down the most often, is when people don't realize what their rights are. And then they find out, gratefully they find out before they've signed the paperwork though. So it's actually a good thing, as tough as it is to get through.
What are some other details that people overlook that can create problems later, even if everything feels straightforward at the time?
That's something that's really important to be mindful of. And I talk about this on a previous podcast. It's important to think of family law cases as going through stages. The very first stage is the establishment of the order. The establishment of the order is going to be, I want a judicial order either for a divorce decree or for establishment of custody and parenting time. And either you get to that by a stipulation or a judge signs it at trial. Then you have a court order, right, that you're supposed to follow. Both parties are supposed to follow. In Minnesota, so courts have jurisdiction over certain parts of the case even after the order has been created. Minnesota is going to lose jurisdiction over the property division after the appeal period is over in almost all instances. So there's not really a whole lot that happens after a divorce case is finalized. Except for if a person isn't following the order, but you're not going to be able to change the way that you divide assets usually in a divorce. But Minnesota retains jurisdiction over custody and parenting time, usually until the child is emancipated. And courts maintain jurisdiction over spousal support and child support until the child is emancipated, and then with spousal support until some terminating event happens. So in those cases, you have additional phases. You have enforcement, which is where someone isn't following an order. And then you also have sometimes cases where an order, one or both parties wants to modify an order. In Minnesota, the courts require, in most instances, if you want to change an order, you go through more mediation because for the same reasons that they want you to go through mediations in the beginning. So why do I bring all of this up? I bring all this up because the order that you initially establish, it's super important that you establish it the way that to prevent conflict in the future as much as possible. And so when you're, and really think about it, when you enter into an agreement with someone for creating a custody order or a parenting time, it's a contract. And so it's hard to modify contracts. So you really want to think about what you're putting in there in the beginning. So when we're going through that, it's very difficult to modify any orders that deal with custody and parenting time in Minnesota. But and you want to be aware of what the standards are. So in order to modify a custody label, you need to prove endangerment or kind of like abandonment. You need to prove that. That's a high burden. And so if you want to just change parenting time and you're not restricting another person's parenting time, you have to prove that it's in the best interest of the child. And there's all these factors that you have to analyze. So when you're creating the order in the first place, you want to be mindful of that. And you want to have an attorney that is able to help you articulate. It's not very easy to change the order. If you can't agree in the future, what you can do is you can say, well, let's agree to have a parenting coordinator, which is a neutral that you can assign to the case if you want to change something rather than have to go to court. So one of the things that we end up seeing the most often is kids get older. A good parenting time for a 4-year-old is going to be very limited periods of time away from primary caregiver, and both parents could be primary caregivers because of attachment. But as they get older, they may need to have more time at mom's house and more time at dad's house. And so one of the things that can help, like, it's great that you have an agreement now, but what happens when things change in the future? That really trips people up because they life happens. And so the more that you can fold into, this is what we'll do if this happens. It's just a chess game, right? Like, thinking moves ahead. Mm-hmm. This is what we'll do if this happens. This is what we'll do if this happens. This is what we'll do if this happens. In the initial order, the more prepared you'll be when those things happen. That's nice too, because when you make it formulaic like that, if this, then this, then as long as you're respecting each other's boundaries, when those triggering events happens, it can take a little bit of the emotion out of the equation. So,
yeah, well, thank you so much, Lilie, for breaking this down, especially so that we know what happens when you are agreeing on almost everything. Thank you again.
Yeah, thank you so much.
Well, that is it for today's episode of Dignified Family Transitions with Lilie the Lawyer. If you're navigating a divorce or custody issue in Minnesota and you want to explore a more thoughtful, problem-solving approach, you can learn more about Lilie McRoberts and her work at minnesotasfamilyattorney.com. Thank you for listening, and be sure to like, subscribe to the show, and share this episode with someone who might need it.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.